Hello and welcome back to yet another tutorial on press law. Well, we have been talking about different law related to press and media. Today we'll be discussing about Press Objectionable Matter Act of 1951. This is Susheta Roy from Swami Vivekananda Institute of Modern Science, Department of Media Science. Well, when we talk about press is a institution which is always guided by freedom of speech, which is a constitutional right. But then when we talk about rights, it comes with responsibilities, and rights and responsibilities has to go hand in hand. Now press has become privatized now. So after the privatization of press, there are a lot of people into this. They have made it a business, and now when it's open to all, there has to be restrictions, because until and unless there are restrictions or guidelines for a specific thing, what happens is this institute can really malfunction. So basically, that is the reason in 1951 the Press Objectionable Matter Act came into force. Now, what does it exactly say? The Press Objectionable Matter Act of 1951, it says, in this act, the expression objectionable matter means any words, signs, or visible representations which are likely to incite or encourage person or resort to violence for the purpose of overthrowing and undermining the government established by law or in any state thereof or its authority in any hour or. So, according to the Press Objectionable Matter Act, it says that press really cannot put in any words, signs, or visible representations in the media, like into the newspaper or magazine or a pamphlet or any of these materials from the press part, which can really overthrow the established law or the government, or do anything which can resort to violence, like any sort of like communal problems, or any of the things which can really go against the law of the state, or it goes against the established government of the state. So press cannot do anything which goes against the state or it does any kind of a violence. So the second point according to this act is it cannot incite or encourage any person to commit murder, sabotage, or any offense involving violence, or incite or encourage any person to interfere with the supply and distribution of food and other essential commodities or with essential services, or to promote feelings of enmity or hatred between different sections of people in India, are grossly indecent or obscene or intended for blackmail. So overall we can understand that press cannot do anything which goes against the state. They cannot incite for any of to commit a murder or any of the criminal activity. It cannot go against the food or essential commodities with essential services. It cannot put in any material which inculcates any type of enmity or hatred, or grossly indecent or obscene or intended or for any type of a blackmail. So press has to abide by some strict, I already told you, when responsibility comes with, when you have authority, it comes with a lot of responsibility too. So these are the responsibilities which has to be, these are the guidelines and the responsibilities of the press. Now when we talk about the Objectionable Matter Act, so comments expressing criticism of any law or any policy or administrative action of the government with the view to obtain its alteration or redress by lawful means, and words pointing out with a view to their removal, matters which are producing or have a tendency to produce feelings of enmity and hatred between different sections of the society, shall not be deemed to be objectionable matter within the meaning of the section. So this is an exception. So everything cannot be put as put as like these are the don'ts of a press. Yes, press have some do's too. So anything which is like if it is a policy, it is like alteration or retention of lawful means. So in that case, or it is in the view of removal of matters which is producing out of a tendency to produce feeling for enmity and hatred between different sections of society cannot be deemed as an objectionable matter within the meaning of the section. What else? What are the other exceptions of this clause? So, in judging whether any matter is objectionable matter under this act, the effect of the words, signs, or visible representations, and not the intention of the keeper of the press or the publisher of the newspaper or news sheet, as the case may be, shall take into account. So basically, the intention of the keeper or the press is not important. Important is what exactly is the effect. Maybe the intention was very less, effect was huge. It becomes objectionable matter. But the intention was huge, but effect was zero. So it is not an objectionable matter at all under this act. It's very confusing, but yes, what is this is exactly what it is. Whatever the press puts in, whatever the news, whatever the matter is, if it has an effect on the society, it is objectionable. If it doesn't have an effect at all, it is not objectionable. So the third point, under this act, the government shall subject a judicial decision had the power to demand and forfeit security and demand further security from press and newspaper, to declare certain publication forfeited, to detain imported packages containing certain publications, to prohibit transmission by post certain documents, to seize and to destroy unauthorized news sheet or newspaper, and to seize and forfeit undeclared press producing such publication. So persons who were proceeded against under this act were allowed the right to trial by the jury. Now, Press Objectionable Matter Act, the following central and the state acts are repealed. Now, when we are talking about the Press Objectionable Matter Act, we will have to talk about certain other acts also, which basically has been repealed. It is not into action anymore. Now, the following central and the state acts are repealed. What are those? The Indian State Protection and the Disaffection Act of 1922 has been repealed. The Press Emergency Power Act of 1931 is not into force anymore. The Foreign Relations Act of 1932, the Indian State Protection Act of 1934, and the state acts like the Hyderabad Press and the Printing Establishment Act is repealed. The Madhya Bharat Press Emergency Power Act of 1950, the Mysore Press and the Newspaper Act of 1940, the Patiala and the East Punjab State Union Press Emergency Powers Ordinance is no more now. It's like it is not being, it's not into force anymore. And the Rajasthan Press Control Ordinance Act of 1949 is not into force anymore. So the Prevention of Publication of Objectionable Matter Act, the Prevention of the Publication of Objectionable Matter Act was enacted in 1976 and it's repealed in 1977. So presently, the Prevention of Publication of Objectionable Matter Act is no more into force. Now, when we talk about it is no more into force, that means this is all we have to know about it. It was there were some preventions, there were some do's and don'ts, but presently this enactment is not into any force. But there are upgraded versions of acts, there are upgraded versions of press laws which is in force till now, and the press are absolutely guided by the law of India and well maintained, and the information we get from the press is absolutely into responsible hands. Thank you so much. I'll be back again with another tutorial with press law and the media laws. Till then, thank you and stay blessed.